Assalamualaikum warahmatullahi wabarakatuh. My name is Intan Binti Aspari. My mental number is 1201-7. Today I will present case review from case Halwani again. First of all, the fact of the case. The plaintiff and defendant were married on 8 March 2002 and were blessed with 4 daughters. The plaintiff has filed a claim for maintenance of the children under Section 73 of the Islamic Family Enactment State of Selangor 2003. This case was extended to Majlis Suro on 15 December 2010 to reach a mutual agreement regarding the matter. However, the Majlis Suro has been unable to establish an agreement between the parties. Then the summons was handed over the plaintiff and defendant to appear for the first hearing of the case. The plaintiff filed a claim for 5,350 ringgit for the children's maintenance monthly, 2,000 for additional maintenance and the cost of the children's celebration on an annual basis, and the defendant is required to pay the children's annual school fees each year. The defendant must pay his income or salary deduction as well as the monthly and yearly allocation of child support no later than 30 days of each month that submitted by plaintiff's claim. The defendant provide a statement of defense dated 21 January 2011 in response to the statement of claim. Throughout the proceedings of the case, the defendant did not submit any counterclaim for the child support claim. Parties involved in this case are Halwani, who is plaintiff, and her occupation was not specified. The plaintiff, represented by Encik Ahmad Nazib bin Johari and Miss Nur Ashada binti Osman from Ahmad Nazib and Associate. The plaintiff presented 3 witnesses to support the children's maintenance claim, namely Hafizal, Rafida, and Hazdina. Muhammad Fathil, who is defendant and worked as doctor. The defendant, represented by Mr. Muhammad Junid bin Ramli from Mr. Yusfa Imran and Associate. The defendant presented 2 witnesses, namely Muhammad and one Mat Shihabuddin. What is the issue in this case? The issue in this case are whether the defendant is a responsible person or not. Bear child maintenance based on hukum syara and the law. The second one, whether the defendant is financially and healthy, capable to provide welfare and educational needs of the children. And the last one is whether the standard of proof in mal case is the same as the standard of proof in criminal case. For the argument of the parties, the plaintiff argued that the defendant was obligated to provide maintenance for the children's well-being and needs, as indicated in the plaintiff affidavit. The defendant is a physically fit individual who works as a medical officer or doctor on a regular basis. Furthermore, the plaintiff argued that the defendants also had additional income as a doctor with income earned by working on call and locum every month. The plaintiff also argued that defendant's ability could be seen based on some of the assets acquired by defendants as stated in the defendant's testimony in court. The defendant had 2 cars owned and used by him, namely a Proton Putra car paid 300 ringgit per month and a Nissan Skyline car paid by the defendant RM 1,500 per month. Therefore, the plaintiff argued that the proof that the defendant can support and bear the maintenance of these children. The defendant failed to provide evidence of the monthly liability that he recognized during the counter-questioning. Even the defendant's testimony for the key evidence and counter-question during the trial was inconsistent. During the defendant's primary testimony, he did not articulate the liability that the defendant had to bear accurately and consistently. The defendant also acknowledged that the defendant only bears for his own needs alone and has no new dependents or new family. Furthermore, the defendant has never been declared bankrupt and is very capable of providing for all the needs of the children. So, in the judgment, the court ordered the defendant to pay the child's monthly maintenance of 2,000 ringgit beginning in March 2012 onwards, which is 600 ringgit for each child named Noor ZXX and Noor AXX, and 400 ringgit for each child named Noor IXX and Noor AXX. Furthermore, the monthly maintenance payments for the children be made with the defendant's monthly income, which is monthly salary deduction, no later than the 30th day of each month and transferred into the plaintiff account bank number at CIMB Bank. Additionally, the court obligate the defendant pay the entire cost of the children's necessities and annual school fees. The defendant also needs to pay additional maintenance for the children for festival expenses at least 2,000 ringgit per year, which must be deposited into the plaintiff bank account at CIMB Bank before the 15th of Ramadan every year, beginning in 2012 and forward. Lastly, the court held that the defendant pays all the costs of this matter as they were after it had been interpreted before the registrar. In my opinion, I think it is very natural for the defendant as a father to bear the responsibility to provide for his children in terms of education, shelter, food and drink, and so on. Based on Section 73 of Islamic Family Law, State of Selangor, Enactment 2003, which say it's obligatory for the father to bear the maintenance of the child, whether in his care or not. Next, I agreed on the plaintiff demanding 5,350 ringgit for the monthly maintenance of the children. This is because the testimony from the defendant and plaintiff witnesses, the defendant is a financially and medically capable person. Defendant has no history of illness. And has never been declared bankrupt. This is what was decided in this case of Noor Aini Binti Abdul Rahman against Taib bin Hanafi. The Terengganu Syariah High Court in this case had ordered the father to pay maintenance for the children involved of 2,200 per month for each person as capable children maintenance payment. Additionally, I am very impressed with both parties, namely the plaintiff and defendant, for being able to produce witnesses even though initially both parties failed to reach an agreement and a final word in the Majlis Suluh.